Mark Roseman.
Good afternoon, everybody, and thank you for the opportunity to be here today and at this public forum. Maureen had asked that I explain my Connecticut roots because I've braved the journey from Delray Beach, Florida, to be here with you. This is my home. I reside in Florida for 10 years. Connecticut is my home. I was born in Hartford. My family, my mother's family, my mother and her family are from Hartford. And in fact, I will say that George Kurgo, if you remember George Kurgo, the actor and producer, is my second cousin. We're related to Norman Lear. He's my second or third cousin. He hasn't gotten back to me to tell me, but Hartford is my roots. Let me say this. 20 years ago, I was here. 20 years ago, I was in the Fatherhood Committee, the Connecticut Fatherhood Committee. And I was on the Collaboration Committee, where having founded the Children's Rights Council of Connecticut, I was eager to network with NGOs, municipal government, state government, and looking at ways to improve outcomes for children when parents separate. And by the way, that's the name of my new book, Preserving Family Ties, which is now at Barnes & Noble's. I share this with you. I was asked to do that because it is probably the only book now that you'll find that easily provides all the significant research and how and why you should generate statutes to enable parents to remain more involved in their children's lives. But Connecticut are my roots. I've been to the Oakdale, Tody Fields. My mother grew up across the street from her. Hartford has been home. I'm from Hamden, Connecticut. And it was New Haven Superior Court, or District Court, where my divorce ensued also 20 years ago, or a little more, 22 years ago. That has spurred me to a journey to become a national child custody expert and to have worked with David Levy, who, if you haven't heard, I hope you will know that David helped bring joint custody. Now we refer to shared parenting, but he brought joint custody to nearly 30 states, and I worked with him in DC to help make that happen. I want to tell you that we need to take a look at the status of the family today. And all these courageous people, all these people that come here with their hearts, as mine, is always palpitating, anxious, hearing voices, hearing our words, resonating viscerally with what we experience and what now we want you to hear. It's vital. And it's vital that we use these few moments to be able to do that directly. But today, if you look nationally, 40% of public school children live in single-parent households. 40% of public school children are being treated for behavior modification conditions as ADD and ADHD. And by the way, 70% of kids, and only 70% of kids, graduate high school nationally. Got to put these figures together. Everybody standing here or sitting here, presenting here, are coming here telling you of the blood they shed, of the losses that they've incurred. 20 years ago, and as a matter of fact, 18 years ago, I was involved with the Governor's Commission on Divorce, Custody, and Children. And Judge Grundell, who was lambasted here, and rightfully so, served on that commission. And so did Judge Monroe, who had no business being there, based on my observations in family court in New Haven. And I will tell you that that commission has at its directive to do what we're doing now, collect the data. And I worked, I had casual conversations and meaningful meetings with the then Secretary of the Department of Social Services in helping to put background together on getting that data around the state. But what has been done since then? I will tell you in French, if you speak French, bupkis. All right, it's Yiddish, but bupkis, they did nothing. Zippity-doo-dah. And today, it's not too late. It's too late for many, but it's not too late for those that are here and wanting to share with you. And I want to tell you that you have great opportunities because the needs of our society is so huge. We are imploding, and it doesn't have anything to do with collusion with Putin. It has everything to do with all the mistreatment and the malfeasance of Connecticut courts that sadly continue. Let me reference researcher Ira Turcotte, and it's from my text on parental alienation. The courts frequently expect that forensic psychologists who interview and evaluate family members for custody and child access determinations will reliably testify as to mental health conditions of parents and children. The courts generally accept an evaluating psychologist's opinion in determining their own. However, psychologists differ in their interpretation of data, and thus an attorney who's attempting to assist a client by making a referral to a mental health practitioner in certain PAS cases may unwittingly be causing the client even more problems. So what I would like to do is conclude this presentation, which I have shortened by about 1,000 pages, but what I'd like to do is tell you what I've done in Florida. I went to Florida not because of the weather. I went to Florida because Florida has what I believe and have studied because I worked nationally for 16 years. Florida has among the most progressive set of family law statutes in the country. In fact, they were the first 8 and remains among the first 12 to require mediation when dealing with child custody issues. It's not the case in Connecticut. In fact, to find an attorney, or an attorney shouldn't be mediators because they prosecute, they don't mediate, my experience. But I went to Florida to be able, within a progressive family law climate, to bring a program I started in Connecticut and to create what is named for my mother, Toby, or her Hebrew name, Tova, the Toby Center for Family Transitions. In 10 years, the Toby Center, which provides multiple services for parents going through separation, divorce, and child custody, both clinical and non-clinical services, has become the dominant provider of supervised visitation, therapeutic supervised visitation, family therapy, parental coordination, and mediation in Florida, the 4th largest state. I am so proud to bring my Yankee roots into Florida. The North has risen again, you know. But to cope with my own divorce, I did stand-up comedy for 3 years. So forgive me, I'm sitting down and I'm trying to restrain myself. But supervised visitation is a concept that I have heard several times today. And Representative Gonzalez, you had brought up the subject several times. And I want to tell you, during the break, I had the opportunity and a great opportunity to meet Dr. Miller, who said, you know, Mark, we shouldn't call supervised visitation that. What should we call it? We should call it accompanied parenting time. Parents, when they come to court, they've already signed their death knell. The vocabulary has changed, and they are reduced to figures. Their empowerment has been broken and removed, and they have to fight to preserve their right to remain parents. Now look, 70% of divorces, you know, they seem to work out fairly well. 30%, and when I mean fairly well, I mean it's not the highly conflicted cases that we're addressing today, and which plague the court. I understand that. But I will also tell you that when you look at the matters of family court, and you look at these returning cases, and you look at the resolutions that are so half-assed, I must say, if you look at the murders and the suicides and the abductions that are done too frequently nationally, as well as in Connecticut, which I know of very well, we have obligations to make changes. One thing is stop the rotation of judges. Yes. Stop it. Yes. Hire only those qualified. Get rid of those who are damaging families. Why am I impassioned about this? Because it continues. It's 20 years later. I'm sitting so quietly in the back, listening to these stories, crying inside. And believe me, if I had a baseball bat, a brother named Vinny, we'd tear this town apart. We would do that. But I don't. I have a situation as a therapist, and I'm a trained therapist, and I've learned better. I'm also Jewish. We hire. Okay? So, look, when people break up, whether a teenager or an adult, how do you feel? Quite honestly, in the vernacular, you feel pissed off. You're angry. And so what do? You do what you can do best, and that is to hurt the other party. Let them know how you feel. You know, children have been treated for 250 years in this country as chattel property. They are property, and guess what? A parent who is going to fight for the custody of their children and to alienate the other party is going to do so in a means of hurting the other party, having that retribution. We need to understand that. So I have a number of recommendations. Many of them are in, I have a chapter called Project FACT, F-A-C-T, page 140. And it takes a look at what can courts do now to make things easier for the judges as well as for the parents participating in the process. But I will tell you that not only do we need to rotate judges, but we also need, as was pointed out earlier today, we need to order and require accreditation of those who would choose to adjudicate family cases. Why? Because the determinations made in family court are going to affect families for 6 generations. That's the research. By the way, I know the research. I wrote the book about the research. And I want to tell you that as you go forward, if you would like me to participate in any way, I am happy to. Connecticut is my home. I'm also proud to say that the Toby Center, which provides the multiple services that I mentioned, the visitation, the therapy, the family therapy, we're expanding to Colorado, we're expanding to Toledo, Ohio, and I want to bring it to Connecticut. But I want to say all the power to you for listening now, and hell will break out if you don't make changes in the next 12 months. I will tell you, people are fed up. Connecticut's losing cases, and the divorce rate is as high as it was 12 years ago. Did you know that? It is. Thank you.
Any questions? I have a couple of questions. But
Okay.
First, I have a comment. I mean, I agree with you with the supervised visitation. I think that is kind of embarrassing when a parent is no complaint about neglect and abuse, and they have to go, for supervised visitation. It's the perception that because it's supervised visitation because they are bad parents. And I think that we should change supervised visitation to parenting time. I agree with you.
Yes, vocabulary, thank you. Vocabulary is very important. But also, as was brought out earlier, Representative Gonzalez, is the fact that supervised visitation is too easily ordered. We have nearly 250 cases a year now. I expanded our agency 8 years ago from South Florida to Central Florida and northward. And it is abominable how frequently it is ordered. And that's why one recommendation I must add is that there needs to be an immediate assessment. When families come into family court, there must be an assessment. What are the issues? And I'm not talking in preparation for trial or for hearings. I'm saying, what do we know about this family? Not only about the children and the parents, but what's the relationship between the parents? 18 years ago, with 2 other therapists in Connecticut, we co-wrote a parenting course, which half of the Steve Grants Committee in Hartford agreed with, and the other half poo-pooed. Why did they poo-poo it? Because it wasn't child-focused. We wrote this therapeutically because it was parent-focused. What did Carl Menninger say? Carl Menninger was the pioneering child psychiatrist in this country who set trends internationally. And he said, simply, what children see at home, they will do to society. So you need to work with the parents. So you need to have an assessment of the degree of hostility, the degree of anger, and the root cause. Dr. Miller brought out ACEs. You need to understand what were the traumatic events in the parties' lives. We need to understand what their history is. You must look backwards in order to go forward sometimes. And in family decisions, you need to. But we need to understand that we can take an opportunity and create a matrix, which I have the designs of, which I would like to help you with if that would be of interest. But we need to have a matrix in order to assess families coming to family court and determine what are the levels of conflict and what are the issues in conflict and begin to address them. And not with untrained guardian ad litem, not with untrained judges, and not with untrained attorneys for the minor children. They're all hired guns, sadly. What needs to be done is a reorientation and an accreditation and a professionalization of the family court system. And if you do not do that, that's a shame. But you have an opportunity to do that because you're here, you're listening, you want to know from boots on the ground what is important. I don't want to have to see us come back in another 5 years, because I will not. God willing, I'm alive, but I will send you. I will send you something not very nice.
When should the court order forensic evaluation?
I think we're.
When do you think that the court should order forensic evaluation?
Thank you. I think that's a very important question. And I would say that everything frequently is cookie cutter. That's either to be expeditious for moving a case forward, or it's expeditious to put money in the people's pockets. And I don't mean the people coming into the court, I mean people working in the court system, the attorneys, etc. So when should family forensic evaluations be ordered? When everything else fails. Not at first. Realize they just broke up, they're coming apart, they're angry, they're disappointed, they're fearful, they have so much mishigas, so many feelings inside. Let it dispel, let it give them time, and don't make them take a parenting course right away within the first month. That's absurd. What are they going to learn? You know what they're going to learn? I told you earlier, buckus, zero, nothing. Why? Because they haven't dealt with their anger, their hostility, and their fear. They need to. So forensic evaluations are indeed important, but not at the time when they come into court. Not at that moment, no. It's when behavior modification doesn't work, actually.
Okay. What remedies should the court consider if it can be shown that emotional child abuse?
Thank you. Thank you so much. I think there needs to be, and based on the research, there needs to be behavior modification, which is what the courts do in criminal court. It needs to be done in family court. And that is, if a parent is not complying and obstructing visitation, then there needs to be cease and desist orders at the very minimum. Then there needs to be a coach perhaps brought in to help identify what is bothering the parent that's interrupting the access to the child. Then there needs to be psychotherapy suggested and ordered. Then there needs to be house arrest and loss of custody. Those are the only things that are going to stop it, so that these people don't spend 10 and 15 years or 5 years fighting for their child, losing their homes. This is outrageous. Is this America? This is not America. This is corporate America. Let's talk about life and society. You can't take it with you. You can't take it with you. So live a life of honor and joy and sustenance and support. And you know what? It does take a village, but not the village that we've seen too often. That village needs to come apart. We need to recreate the village, and we can do that. I believe in you. I believe in you, because that's who's here. And by the way, yay for Moderna Pizza. I will tell you this. I'm from Hamden.
One last question. What remedies should the court consider if it can be shown that emotional child abuse is occurring?
Right, and thank you for asking that. And I believe that was a question that Representative Gonzalez had just asked. That was my interpretation. And I would say that as the legal system has done in criminal court, they need to identify that any effort by a parent to interfere with access by the other parent with their child is criminal. And so what do? You issue cease and desist orders. It's got to be routine. You must stop it, and it must be enforced. Police in the system, police in the city, anytime someone cannot see their children and they want to call the police, which is natural because you figure the police are going to protect you and the rights of your children, they do not. They say, oh, you got to go back to court. No, not my, it's not my, ability, my authority to do that. I think that may have to be relooked at. Because if we can stop domestic violence, when does domestic violence appear? Dr. Sanford Braver at Arizona State University said, domestic violence is found most frequently 6 months before and 6 months after a divorce. So what else can we do? Cease and desist orders, Co-parenting education require therapy with that parent, who I'll call the objectionable parent, order them under house arrest, and threaten them with the loss of custody. I think that's really critical. You have to do everything that you would in criminal court. By the way, let me just add one more thing. Bill Coleman. Anyone know the name Bill Coleman?
Yes. Yes.
Okay. Bill Coleman spent 12 years in prison, right? I went to his trial. I wasn't living in Connecticut. I was living in Bill Coleman did not have the opportunity to testify in his own defense. He had two attorneys. One was disbarred, the other one turned in his license. He still went 12 years in prison. And why? Because he had sole custody of his children. And that was a case where the wife had taken the children illegally to England. You ask, how can something like this happen? Only in America. I should talk to Norman Lear about it. But there's a lot to do. Thank you.
No, thank you for your testimony.
Thank you.